All right, good morning, everyone. Welcome to day 2.
Good morning, Gary.
Good morning, Eric. Thank you for your response. That was quite kind of you. As they say, no plan survives first contact with the enemy. That's the little army in me. But so we had some traffic matters and such this morning. We've also lost one of our panelists to COVID. We got informed last night, so you won't see Drew Bagley on the dais today. But nevertheless, we are well provisioned here with a wealth of expertise to take this discussion on, but Taylor Grossman, who is the Deputy Director for Digital Security at the Institute for Security and Technology. I'll take a quick digression to put in a plug for IST, doing great work. My friends and former colleagues, Megan Stiefel, Stephen Kelly, Taylor over there as well. But 22 October, we'll be announcing soon. We have a separate event we're co-planning with IST and some others on sort of how to operationalize public-private collaboration and partnership in the cyber domain. That is a constant theme of the need for partnerships, both internally with the private sector and internationally. But that's how do you take that to the next level beyond just some information sharing constructs? That's what we're going to take a look at. So mark your calendars. Previously a researcher in the Cyber Defense Project at the Center for Security Studies at ETH Zurich, also with Carnegie before, has been doing tons of research in this space for some time now. And I will turn it over to Taylor. She managed to fight off the Uber car accident and get here. So ready to launch on this discussion. Thanks, Taylor.
Good morning. Thank you all for bearing with me. I'm from California, so I'm used to bad drivers, but I think they're actually here now. But all is well. I hope you all enjoyed yesterday's discussions as much as I did. I'm excited to jump right in on a conversation about the intersection of cybercrime and statecraft. So just fair warning, I am not a lawyer by training. My background is in political science and international relations, which may or may not be a good thing for this panel. But luckily, I am joined by 3 extremely qualified folks to talk about this topic. So I'm just going to give a brief background. We could spend all day talking about their amazing accomplishments and expertise. And then I will pose a few scenarios. This is a huge range of issues and potential questions that we could tackle, and I hope we'll go in lots of different directions. And then I will turn it over to them. So first, we have Asaf, Lubin. All right. Great. We practiced before, but it's been a couple weeks. He is an associate professor of law at Indiana University's Maurer School of Law. He's also a faculty associate at the Berkman Klein Center for Internet and Society at Harvard, and an affiliated fellow at Yale Law School. He's held a number of academic and governmental employee positions, including as an expert contributor to the UNODC. Then we have Arthur Traldi, who is a senior fellow with the Tech Law and Security program here at American University. From 2010 to 2017, he served as a prosecutor at the International Criminal Tribunal for the former Yugoslavia, where he litigated cases involving violations of the law of armed conflict. He has worked on submissions to the ICC, the US Supreme Court, and many, many others. And then last but certainly not least, we have Liis Vihul, who is the founder and CEO of Cyber Law International, which provides consultation and training services in international cyber law and other security-related fields. Previously, she worked at the NATO CCD COE, and she was the managing editor of the Talon Manual, 2nd edition. So again, as I said, this is a very broad field of discussion. I wanted to pose, again, 4 scenarios, just to not even limit our scope, but just maybe to set the scene a bit. And these are areas where, when we discussed, we thought these questions had particular relevance when we're talking about, again, criminality and statecraft in the field of cyber security and cyber attacks. So the first potential scenario, right, is state-sponsored or conducted espionage. right? This is criminalized under domestic law of the country where this is usually being conducted, but murkier in international law. And there's obviously a real range of activities from sort of traditional intelligence operations to international intellectual property theft and other areas. The second is ransomware, data theft, and other more common criminal activity. Right, states have a range of possible roles in this area, from potentially, not being able, not having the capacity to be able to stop these activities, right? So we get into due diligence concerns, or they might be encouraging or supporting or even bankrolling these activities. Third, we have spyware, right, which is definitely a growing issue, being addressed in a range of fora, from the Palma process to the European Parliament. There's a number of questions in this area. Two in particular would be around the appropriate targets, right, from political adversaries to human rights activists, right, political dissidents that gets into other issues of human rights law, and also privacy concerns. And there's also the question of infrastructure and development of the tech, right, where we get into procurement and export controls and sort of what should be permissible and legal in terms of selling spyware. And then finally, we have actions that a state might take in furthering their war aims. And this would be often through direct action. They could be using proxies, but this is where a cyber attack or a cyber-enabled attack is used to achieve physical effects, right? And there we get into more traditional questions of IHL. But again, there's a range of ways we could think about whether or not that's legal or illegal. So I'd like to invite the panelists, I think we'll just go down the row, to take a moment, react to anything I said or nothing I said, and then we'll go from there.
So thank you, Taylor, for setting the scene and for the kind introduction, and Gary for inviting all of us to speak today. In preparing my remarks this morning, I was struck by the title of our panel, Combating Criminal Statecraft. I think it might be helpful for us to break down some of these terms. Statecraft is the art of employing diplomacy, military power, economic influence, political maneuvering to achieve a nation's objectives. At its core, statecraft is about the ability to shape events, both within a state in its interactions with other nations, to secure national interests. When we speak of criminal statecraft, we speak of situations where a state employs illicit means to achieve the same ends, where a state leverages criminal syndicates, or where it resorts to methods that undermine the legal order, such as in the case of violence. We may be able to say that the state has stepped into illegality, that it has embraced delinquency as a modus operandi. So Taylor gave us a number of scenarios to play with. I'll focus on two, ransomware and espionage. Ransomware as statecraft offers a good illustration of that moment where a state steps into illegality. It's a crime where the perpetrators seek profit through extortion, targeting vulnerable institutions like hospitals or entire cities. What makes it even more insidious is how states can distance themselves from the crime while indirectly benefiting from the chaos. The state offers a kind of safe harbor to these criminals, allowing them to operate with impunity so long as they direct their attacks outward. As long as the crimes don't hit at home, the state turns a blind eye, tolerating and even fostering the disorder these criminals create, knowing it can weaken their geopolitical adversaries. Ransomware isn't just a crime against individual victims or organizations, though. It is a crime against society itself. In previous work that I wrote titled The Law and Politics of Ransomware, I argued that ransomware belongs in the same category as maritime piracy, hostage-taking, aerial hijacking, terrorism, and human trafficking. What all these crimes and the crime of ransomware share in common is a set of important features. First, they are all threats to the international movement of goods, services, and persons. Second, they all have transnational components that expand beyond the purely domestic environment of one state and complicate reliance on national prosecutions. Third, they all involve offenses against a core human and universal value and freedom. Fourth, they all involve relatively low costs to perpetuate the assaults. And finally, fifth, they all generate massive victimization on scale due to the indiscriminate nature of the attacks, thereby shocking the conscience of the international community. It is in this context that ransomware is a malum in se, an evil by itself, and that ransomware gangs represent modern-day hostis humani generis, or enemies of mankind. I therefore strongly believe in the need to anchor ransomware prevention strategies to other historically successful efforts in international criminalization. So far, policies around ransomware prevention, including those promoted by the Biden administration through the 50-nation International Counter-Ransomware Initiative, have centered around the need to exert pressure on nations that are providing safe havens while developing capabilities and sharing information to fight back. What hasn't been attempted is actual international criminalization, proclaiming the international character of the crime, affirming the universal jurisdiction rights of each state to apprehend and punish offenders when they enter into their shores, and requiring them to abide by the principle of prosecute or extradite. In other words, recognizing ransomware as criminal statecraft entails employing the same playbook for ransomware gangs as we did for transnational organized criminals and terrorists and hijackers and pirates. Now let me turn briefly to espionage, because this is where things get more complicated. Espionage, for all its moral ambiguity, has always played a role in statecraft. Whether we like it or not, states spy on one another for different reasons. Some may do so in defiance of the legal order, but others may do so to preserve it, to protect international security, peace, and stability. Not all share this view. 50 years prior to the materialization of the campaign to outlaw war in the Kellogg-Briand Pact, a failed campaign to outlaw espionage was attempted in the Netherlands. In 1880, as part of a drafting of the Manual on the Laws of War at the Institute of International Law, a proposal was made for a treaty to be adopted, suppressing all forms of espionage. It was promoted by the belief that espionage was indeed malum in se, an evil by itself. As one commentator of the time wrote, among the most repulsive phenomena in the peaceful relations of states are espionage activities, as they get in the way of reasonable rapprochement among nations, which could lead to healthy relations and eventually to legally ordered cooperation. The former Dutch Minister of War and Rights, which name is too long for me to read to you, issued a strongly worded note in response to the proposal, quote, challenging the usefulness of such prescriptive measures, end quote, which was indeed eventually rejected. In a world without centralized and compulsory enforcement mechanisms, states were not willing then and are not willing now to criminalize, ban, and outlaw espionage as a matter of international law. This is not to say that espionage need not be regulated. I've spent my career proposing tailored, nuanced, and fit-for-purpose international regulations for intelligence gathering. Rather, what I suggest is that espionage cannot be internationally criminalized. Of course, certain acts of spycraft may indeed reach the level of an international delinquency. The theft of intellectual property for individual commercial gain and other acts of cyber economic espionage may be prohibited, as both the Obama-Xi Agreement and the G20 Communique of 2015 affirmed. Similarly, spying to advance other personal benefits or to support manifestly unlawful acts, like annexation of territory, may ultimately be criminalized. If we wish to fully appreciate how and why only certain acts have come to be recognized as international crimes, it is not enough to just focus on the question of whether the prohibition of the conduct has been codified in a treaty, or whether international courts have been granted the jurisdiction to enforce against individuals and states for committing these crimes. Rather, it is important to assess the intrinsic characteristics of the conduct itself. Ransomware is not just a crime against one state or one victim. It threatens to destabilize the infrastructure we all rely on. And crucially, unlike espionage, it offers no legitimate or strategic function that may counterbalance potential harms. Ransomware is extortion, pure and simple. It is an assault on innocent populations, a direct attack on the shared institutions that allow nations to thrive in a globalized world. It is a malum in se, a crime whose very nature is corrupt and destructive, seeking chaos and profit. Today's panel invites us to think beyond ransomware and ask the question, which crimes should be internationalized? It is in that sense that I'm particularly happy to be here.
Thank you. Arthur?
Thanks, Taylor, and thanks to Asaf. Thanks to all of you for being here. It's a pleasure to be with you and to be part of TLS as always. So I'm starting at a little bit of a disadvantage, which is that I've also begun my notes with the definition of criminal statecraft. It's a little bit different than Asaf's, and it's early in the morning, so my imagination isn't working very well. So I'm going to offer it and see if you can perhaps integrate the two of ours and come up with your own third definition, which you'll share during the Q&A process. So what I think we're talking about very simply, very basically, when we use the term criminal statecraft is, number one, conduct which constitutes a crime under international law or under the domestic law of a relevant state with jurisdiction, and which, number two, a state, not necessarily the same state that criminalizes it, engages in pursuit of its kind of macro foreign policy objectives. By a state engaging in conduct, I mean, similar to the draft articles on state responsibility, that the conduct is either conduct of a state official doing their regular job, conduct pursuant to state policy, or conduct directed and controlled by the state. And that takes me to, I think, one of the big challenges in dealing with criminal statecraft, which is, well, first for me, that while Taylor said she's not a lawyer, I'm not a statecraft professional. So perhaps Asaf and Liis do both, but Taylor and I can add up to one panelist on this topic. But the second is that unlike pirates, right, the person committing the crime here is acting on behalf of a state. In fact, the state that is best placed to investigate and prosecute under normal circumstances. And that creates some real impediments to what would otherwise be the natural way that things would be investigated and prosecuted. Picking up on Asaf's historical analogy, you know, in the exact same context that he's describing, what we would have called people acting on behalf of the state is privateers who were not hostis humani generis, who were issued letters of marque and reprisal that authorized them to engage in the conduct that they were engaged in. With that said, and that kind of practical challenge in mind, I'll take one of the examples that Taylor gave as a jumping off point, and here, thankfully, I didn't pick exactly the same one as this. But I think about, from my professional background, things like the attacks, cyber attacks on power grids that she described. And this is something like traditional force, right? The state engaged in this perhaps criminal statecraft is using cyber means to produce physical consequences in the real world that impact an adversary. So for instance, if a state's got a hacking group that answers to them and that group hacks and turns off another state's power grid, the actual action takes place in the cyber realm, but unlike Las Vegas, what happens in the cyber realm here doesn't stay there. In the physical world, the grid goes down. In the physical world, homes without generators don't have heat. In the physical world, maybe you have traffic accidents because lights don't work. In the physical world, maybe the attack is combined with missile strikes and an air alert app doesn't work the way it's supposed to, and the amount of civilian harm that's caused is increased. So this is essentially a way that states may use cyber means to engage in attempts to impose physical consequences on their adversaries or their perceived adversaries. I think there are a couple of similar and slightly more upstream ways that states may use cyber means to facilitate atrocities. And one that we've done programming on here that I think fits within the cyber statecraft is where states are using cyber means to motivate people to target perceived adversaries, particularly for acts of criminal violence. So an example that's often discussed is the use of or misuse of Facebook primarily by Burma's government a few years ago to disseminate propaganda against the country's Rohingya minority around the time of large-scale ethnic cleansing operations by the country's military and others targeting the Rohingya that the US State Department subsequently determined constituted genocide against the Rohingya. And so in that sort of example incident, cyber means are used to disseminate propaganda that's intended to prompt targeted violence in the physical world. And that also, thinking back to the definition, may likely be a crime under those circumstances if the propaganda, number one, either directly and publicly incites genocidal actions, or two, if it's intended to and does have a causal effect on individuals who hear it, receive it, then going out and committing crimes. Then maybe a step further upstream from violence, thinking about using cyber means to destabilize adversaries and their governing processes and spur conflict in the streets, for instance, by doing so. It's just last week that we had the most recent report that an American presidential campaign had been hacked by a foreign state, and that state tried to give the data to the opposing campaign. This is not, as we know, unusual in recent US elections. In fact, there are notorious hacks by different US adversaries of campaigns on both major American political parties. And those have been paired as part of kind of the same information operation with the dissemination through cyber means of propaganda or information warfare. And Maggie gave, I think, yesterday the example of the Freddie Gray protests in Baltimore, where a foreign actor had managed to spur Americans onto the street. What I suspect was a fairly low investment of money and time, confronting each other in a way that could easily have escalated into a dangerous situation. On both those, I suspect those states are trying to both destabilize what they perceive as an adversary's governing process and to use information they collect to impact the result here of an election or the impact the result of a policy decision. And those actions, of course, may also involve a variety of crimes ranging from identity theft to hacking. So I think we see a lot of ways that states are engaged now in exactly this type of criminal statecraft, trying to use it to harm adversaries, including physically. I'm looking forward, as Asaf is, to the rest of the conversation about that.
Thank you so much, Liis.
Good morning, everybody. Well, being the third speaker to have paused on the title of our panel, I think I'm at the biggest disadvantage here. But I think the reason why we all pause for a moment has to do with the fact that international lawyers don't usually think of those two notions of criminality and statecraft in the same breath, right? And instead, whether actions of statecraft in cyberspace are permissible or not, we determine in reference to international law rules, not the domestic legal rules of the states involved. But that said, there are interconnectivities between the two notions, and I picked a slightly different angle to this topic. And there's one angle that I've always found particularly interesting, slightly more from a political perspective than from a pure international law perspective. But it is this practice of some states, predominantly the practice of the United States, of resorting to its domestic criminal justice system to solve an interstate problem. And what I'm referring to is the bringing of charges by, again, mostly the United States, but also some other countries against foreign hackers that clearly have engaged in state-on-state, politically motivated cyber activity. I believe today in the United States, there are around 200 hackers that have been indicted. And the latest in this long list of indictments are the Whispergate indictments from just this month. And it was interesting to me to discover that Estonia, which is the country where I am from, also exercised its enforcement jurisdiction with respect to the Russian GRU hackers who had engaged in cyber operations, primarily against Ukrainian cyber infrastructure, but also against Estonian governmental assets. And with regard to Estonia, this exercise of enforcement jurisdiction involved the request of and issuance of arrest warrants concurrently with the United States indictments of 3 of the same individuals that the US indicted. So it's an interesting phenomenon, like I said, from a political perspective, but with regard to international law, to me, there is a hardcore public international law issue involved here as well. And it's the question of functional immunity, right? So for the international lawyers here, this is a familiar concept, But functional immunity is a longstanding rule of public international law, customary international law, whereby foreign state officials enjoy immunity for the acts that they have performed in an official capacity. So here, at least on face value, we seem to have a problem. On the one hand, we've got foreign state operatives engaging in state-on-state hacking. And on the other hand, we have this longstanding rule of international law whereby state officials acting in an official capacity enjoy immunity from the exercise of jurisdiction by other states. And when the US first started issuing those indictments, we had some conversations among our groups of international lawyers as to how the issue of functional immunity played out in those indictments. Some of the earlier indictments were for theft of intellectual property, for example, by Chinese hackers. So our conversations would go along the lines of, well, if they're stealing intellectual property as Chinese government officials, can we really say that they are performing a state function? Is it a state function for government hackers to steal the intellectual property of other states for the purpose of giving their own state a competitive advantage? So at least by speculating, that seemed to be a possible way out of functional immunity being breached. Sometimes the individuals who have been indicted, they've been state proxies. So there, removing the functional immunity problem seems much easier. But if you look at this very recent Whispergate indictments, then there does not appear to be a get out of jail free card. I mean, they're GRU hackers, they're working for the Russian military, they're hacking foreign government systems, that they do appear to be carrying out official government functions. I mean, today states have hacking units across the government in law enforcement, intelligence, in their militaries. Hacking is increasingly a 9-to-5 job, a state function. So there does seem to be this problem here of is the exercise of jurisdiction by states that either charge those individuals, that issue arrest warrants, as to whether they are violating those individuals, those states' right to the individuals enjoying functional immunity. And to me, this is a fascinating legal question, and it's fascinating. It would be fascinating to know what the legal thinking in those governments around this issue is, and how much states are even considering the question of immunity. So when I think about the Estonian context, where you've got an Estonian prosecutor turning to a Estonian prosecutor applying Estonian domestic criminal law, turning to a county court, requesting a judge in a court of first instance to issue an arrest warrant, I'm pretty confident that in this proceeding, the issue of functional immunity does not arise, not in the prosecutor's office, not in the court system. And the only potential input of this regard in the Estonian system would be from the foreign ministry, I would think. This is the only place where that kind of expertise would lie. So I'm not sure if in the Estonian case there was any discussion of functional immunity. It would be fascinating to know, but more importantly, in the American context, does this mean when states exercise enforcement jurisdiction against foreign government hackers that, first of all, they're considering the question of functional immunity? Does the issue arise? If so, if it arises, how do states get around it? Or are we simply seeing the first steps by a country in trying to change those longstanding rules of international law as they relate to functional immunity? So definitely, in my opinion, a topic worth doing proper legal research in, doing a proper study of the indictments and seeing whether there is anything to pull away from them in regards to the specific issue of immunities.
Thank you so much. So lots to dive in here. I want to start by talking a bit about incentives, which I think that everyone has touched on in their own way, right? I think when we initially think of crime, right, financial motivations are key. That can often be one of the distinctions, as you said, Liis, right? When we don't think about criminality in the framing of statecraft. But all three of you have touched on different types of incentives and also why a lot more sort of traditional criminal activities are being folded into state apparatuses. So maybe Arthur, I'll start with you. I don't know where you want to pick up on this attribution, plausible deniability issues, but how do you see incentives playing out?
So I think you're right to say that when a state acts through proxies, as you said in the introduction, then one of the incentives is avoiding or making attribution more difficult, maintaining plausible deniability about the conduct. More generally, I think yesterday you've all quoted the Digital Compact as saying that it rests on international law. I think the incentives states have here to engage in this type of criminal statecraft generally rest on the same incentives that they have to engage in traditional power politics through other non-cyber means, whether that's imposing direct physical damage to an adversary, whether it's unifying their population against somebody they perceive to be an enemy, whether it's destabilizing an adversary, perhaps by compromising their elections or their governing processes, or protecting their own stability in the spyware context, for instance, by surveilling, compromising, or intimidating people that they believe to be threats to that stability. So I think it's the same types of incentives that we see for traditional state behavior.
Asaf, I wonder if I can turn to you. I promise I work on the ransomware task force. This will not all be about ransomware. But I was struck by, when we think about ransomware, there's obviously huge dollar signs, but they're also, right, if you're folding it in with terrorism and other major transnational issues, there's huge problems around victimization, right? And again, some of these traditional power politics. I'm wondering if you want to elaborate.
Yeah. So before I do, I just am so engulfed by the things that have been said already that I do want to also react to some of the things that have been said first. So I think that one of the things that our conversation so far has demonstrated is the ways by which these activities are pushing the edges of existing doctrine and are forcing us to rethink what our understanding of those doctrines are. So one issue is on this plausible deniability stuff and a lot of the things that Arthur talked about. It pushes us to rethink due diligence and complicity and the way they might trigger state responsibility or state liability in these circumstances. How do we define the relationship between the state and Facebook in the context of the genocide in Myanmar? How do we define the state's activity involvement in the context of the activities of GRU? And on that point, specifically in response to the really astute observations that Liis made, I'm curious to suggest two ideas to you on the functional immunity side. One directly ties to acknowledgement. And we've seen a lot of that in the espionage discourse, where if the country doesn't admit that it's been spying, it's like the James Bond quote, right? You do it on your own peril. If you get caught, we disassociate ourselves with you. There's this question about if the country never admits that these people are its own and that they've conducted these acts on behalf of the state to carry out state action, are we able to then plead functional immunity? And do we, and especially in a lot of these unilateral activity that is being carried when there is no other side in ex parte proceedings to push back and suggest functional immunity, the state can just come in and say, well, Russia doesn't admit it even done any of these. And so there is no ability to claim functional immunity on the other side. And so again, I think that both of your claims around due diligence, a relationship between the actors might trigger some interesting discussions. But I take your case and bring one over it, which is exercises of unilateral cyber enforcement activity. Botnet takedowns are also carried out through the courts. You go to the court, you ask the court to cleanse computers abroad through internet service providers in ways that equally trigger the questions of the application of the prohibition on extraterritorial enforcement jurisdiction in new and innovative ways. And theoretically could also, should states claim botnets as their sovereign assets, from which states should not be claiming to have any touch or control over. I think what I'm getting at is that all of these generate really interesting questions. So that was my reaction. I'd love to hear your thoughts. But to the question I got, which is about ransomware, is about ransomware and victimization. I think that what we're seeing, so there was a case that manifested in the courts here. I teach torts when I don't teach international law and cyber. And there was a plaintiff who came to a hospital to have a baby. And the hospital failed to inform her that the hospital was under a ransomware attack. And as a result of that, we're able to only carry their activities up to 80% of what their regular activity would have been. It turns out that there were complications in the pregnancy, which she attributes to the ransomware activity denying the hospital from being at full capacity. And so she brought a negligence suit and claimed that in part that the hospital owed her a duty to inform her about the ransomware attack so that she could choose to go to a different hospital. When we talk about victimization, I think that whether or not this case is ultimately settled, but whether or not the people who are victims, real victims of ransomware, might feel the same kind of reactions that victims of these other crimes are listed might feel about the under enforcement on the part of the state, about the degrees of harm that might manifest and the need for enhanced security, in part through international collaboration. So I'm not fully alarmed necessarily by the equation. Sorry, that was a very long answer.
No, thank you. I want to pause also. I apologize for other reactions to opening remarks before we move on to some additional questions. I know we haven't let Liis, if you have some.
I think Asaf's point is really interesting. I think in effect, what you're referring to or what you're distinguishing is, on the one hand, the legal risk involved in a particular activity. But to me, this is a separate issue from the actual lawfulness of the activity in question. So in the espionage context, you might characterize some cyber operations, espionage operations as unlawful, as a strict matter of law. But then it's a separate question as to what is the legal risk involved in engaging in that unlawful cyber operation. And that legal risk may be very minimal. And I think the same dynamic might be playing out in the context of functional immunity. As a strict matter of law, we might see a violation here, but what is the legal risk of breaching functional immunity? Well, maybe it is close to zero because Russia will never admit that those were the GRU officers who engaged in the hacking. Russia will never protest the exercise of enforcement jurisdiction. So I would distinguish between the lawfulness, strict lawfulness or unlawfulness of the cyber activity and the legal risk as such. And when it comes to the extraterritorial law enforcement context, then what I've observed is that there seems to be, again, a difference between how states act in relations with their like-minded partners, close allies, as opposed to states with whom they might have more adversarial relations. So I'm pretty sure that when the FBI engages in law enforcement activities abroad, when those activities involve European states, I mean, we're constantly in the news reading about, joint law enforcement operations, joint botnet takedowns, but I'm not sure that the situation is exactly the same. The FBI turns to its foreign counterparts when it involves, criminality in other not that like-minded countries.
My two quick thoughts. Yeah, I completely agree with everything you just said. One, it reveals my priors, which is that I'm not a positivist. I think of very New Haven school-y kind of person, and so these interactions about it's unlawful, but there's low legal risk. To me, is the law not capturing both? Is when we conceptualize what the law is on a matter, should we exclude the practice, the understandings, the underlying political back and forth, and in part also the double standards that are so uniquely tailored to a lot of this gray area activities? Or should we embrace the notion that the law is in part in a state of flux and in part is about the ebbs and flows and power dynamics with countries pushing back and forth in the shaping of what the ultimate norms would be around these issues? This is my best attempt at echoing Michael Reisman, though. No one besides him can echo Michael Reisman.
I would like to stay on this point. I think we've touched a bit on the intersections between domestic legal structures, enforcement, and international law. And of course, with different types of criminality, these intersections and interplays are very different. So I'm curious, I would love to throw it back to you, Liis, to talk a bit about, you've already mentioned this in the case of functional immunity. We've also heard, right, Asaf, in terms of ransomware and other criminal activities, when law enforcement agencies have seemed to take sort of, there's been a domestic framing. Clearly big trade-offs in the way that these different frameworks interact. So I'd love to start with you, Liis, about, again, functional immunity, and if you wanted to pick up some of those tensions.
Mm-hmm. Well, I think as a general matter, still states, they resort to their domestic criminal justice system to deal with genuine criminality. And when it comes to interstate relations, I think the number one vehicle still is international law. And the resort to the domestic criminal justice system to deal with an interstate problem is sort of a unique mix of the two, if you will. But being an international lawyer, I'll focus my remarks on international law and specifically the question of enforcement, right? Because here we're dealing with the question of how do states protect their rights in the face of statecraft in cyberspace activities, malicious cyber activities by other states. And I mean, we are, no question, witnessing states struggle to enforce their rights vis-a-vis other states' malicious cyber activities. With regard to the response options that international law provides, international lawyers are well familiar with the menu of response options, starting from those that are very much institutionalized, judicial proceedings, involving diplomatic responses. And on the multilateral level, the discussion very much has focused on unilateral self-help measures. And this is also interesting because here we can clearly see the effect of the Western formulation of the subject matter, this primary reliance on unilateral extrajudicial response options, and focusing on those rather than perhaps more structured, more institutionalized responses. With regard to states enforcing their rights vis-a-vis other states' malicious cyber activities, some people in the room have heard me mention this just not too long ago, just a couple of weeks ago at a different event. And I'm going to keep beating on this drum because this, to me, really is the missing piece of the puzzle. And it has to do with the fact that up until today, we've not really seen states publicly condemn other states' cyber operations as violations of international law. As far as I know, there's only been one case. It goes back to 2018. It was the 2018 UK condemnation of Russian various cyber operations as being flagrant violations of international law. But back then, that statement also came not from the Foreign Office, it came from the GCHQ. And so I think that's a separate question of as to how coordinated that characterization within the government was as those operations being flagrantly in violation of international law. But other than this one example, I'm not familiar with any where a state has publicly pointed a finger at another state and said, this cyber operation violated my legal rights. We've seen quite a few, and this is arguably an increasing practice of states condemning other states' cyber operations as breaches of norms of responsible state behavior. And I understand it is, for example, EU policy that they will always also identify that particular norm of responsible state behavior that was breached. But we've not seen states, again, like I said, condemn operations as unlawful under international law. And I recently at an event asked the state representative why that is the case. And I got an answer that I'd heard before. And the answer was that we don't want to make such accusations unless the pointing of the finger is accompanied by some other sanctions, right? That the pointing of the finger alone is not going to be enough. And it might suggest to those other countries that actually, the risk involved in acting unlawfully in cyberspace is very minimal because everything that is going to follow is just the pointing of the finger. And this to me is a very interesting line of thinking, and I'm not sure I fully, say that, yeah, that makes sense. I agree with it. To me, it ultimately boils down to human psychology. So if I think of like day-to-day situations, if I were to park my car in a handicapped parking spot and somebody caught me doing that and said, hey, what's up with that? This is reserved parking. I'd be mortified. Or if I didn't pick up after my dog, it would be very embarrassing if I got caught. Or if there was a kid waiting to cross the pedestrian crossing and I kept driving and I didn't let the kid pass, and then another driver pulled up to me and started gesticulating, I'd be mortified. But here, in a social setting, this is an analogy. It's just calling out bad behavior. So to me, and in some cases unlawful behavior, like not letting the kid cross the street. So to me, I think it's appropriate to analogize to an interstate context. And this leads me to think that this position whereby it's not going to be appropriate to call out other state cyber operations as unlawful without any additional sanctions slapped onto that condemnation, like expelling diplomats or imposing economic sanctions, whatnot, is really going to have to be a case-by-case decision. And there should not be an assumption that it's always going to be inappropriate. And in this assessment, I would look to the state that is being condemned, and I would ask the question, well, is this condemnation vis-a-vis that particular state in this particular context going to achieve its intended purpose or not? I think it was very embarrassing probably for the United States when the Snowden revelations came out and the US, so to say, got caught with all sorts of operations in cyberspace. And some countries are going to feel more embarrassed than other countries when they are called out. I would not definitely assume that when Russia and China are called out, that they are not going to care about that they're not going to care about the pointing of the finger at them. I do think that they care very much about their reputation. Why else would they go to such lengths to justify their actions, cyber or kinetic, also in international law terms? I mean, for Russia, the war in Ukraine is something that they justify on international law grounds. So the pointing of the finger at Russia, you're a bad state that is violating international law, to me at least, it has some weight. Is it a sufficient enough deterrent for those countries to refrain from malicious cyber activities in the future? Maybe yes, maybe not. But I think the main point that I'm trying to make here is that just assuming that an accusation alone is always going to be inappropriate is not necessarily convincing.
Asaf, I wonder if I can turn to you. I think this question of, is pointing the finger, is raising blame enough, is incredibly right. It's incredibly rich topic. And there's so much to discuss, particularly right when we think about more traditional acts of criminality, but also in espionage, both of the cases that you mentioned. States, and I'm thinking primarily the United States, right, have taken a range of different approaches to levers that they use.
So great. My immediate reaction is to say that there's no question in my mind that we need greater elucidation through public statements of the kind that Liis is talking about. But I also don't want to diminish the value that back channel activity, some of which is known by the actors involved, though not publicly reported, should not have equal merit in our understanding of the way the world works, and therefore should not equally matter. And I will note to you that the ILC had mentioned in its identification of custom international law, made a reference not only to regional custom, but to particular custom, where it talked about states who share a particular set of activities or knowledge, shaping particular customary obligations binding them. And so I do think a lot about the non-public, yet generally known among the like-minded, or generally known among even the adversaries who have their rules of the road as shaping important conversations that is often, again, missed in positivist, formalist ways of thinking about the evolution of international law. Just a few more points related to that. So one, Liis did a great job of kind of mapping the various tools in the toolbox that states employ both domestically and internationally to go after cyber criminal. What my opening remarks mentioned just an additional tool, which is international criminalization. And what I suggest in the context of that tool is twofold. One is that it's not unrealistic as it might seem. The ICC's, the Office of the Prosecutor's announcement that it will start looking at certain cyber activity as playing a supportive role in the existence of crimes is a first step towards mapping out particular criminal conduct in the context of cyber, thereby potentially setting the scene for international criminalization, which for the point that Liis made before about functional immunity might also be a solution, because after all, a state official cannot claim functional immunity in a domestic court for an international crime. And so to the extent that we criminalize that act, that might also solve some of these problems. There's two other sets of tools that Liis did not touch upon. One is this increasing role on public-private partnerships and the increasing reliance on corporate activity to conduct a lot of the investigations and enforcement action. And it's predominantly the West employing big tech giants to go after, Microsoft, to go after a criminal actor. And I see there are two problems. One is that we've been talking about criminal statecraft, but there's also the question of what happens when a corporation acts like a state. And the reverse of that, what happens when the state relies on a corporation to further distance itself. So instead of, in the past, so far we've talked about criminal syndicates or ransomware gangs, and the state is distancing itself by relying on them. But if you're relying on a corporation, and then you're saying the corporation is allowed to do it because it set out a complex contractual framework of its own design, and then design software that it controls, in which it has the full capacity to change realities in real time, to reallocate property interests. In that space where we've created a cyber domain where these corporations are fully in control, those corporations are acting with impunity because they're not subjected to any explicit international rules as such. It gets really complicated precisely of the kind of the Facebook Myanmar situation. And so it, again, pushes us to reconceptualize public-private. And the last thing I mentioned is what I was starting to talk about before. Even when states operate, not through corporations, but as a collective to bring enforcement action, say, as the IST has long promoted, to seize hot wallets, to take action to prevent, to circumvent in real time ransomware gangs by taking down botnets that are carrying out these attacks. Or a more controversial approach, defend forward and positioning, in order to investigate and determine in real time who is doing what where. Those sorts of activities all involve exactly the kind of stuff. I wasn't here yesterday, so I missed the conversation on the Cybercrime Convention. But a lot of what this has resulted in countries like Russia and Brazil refusing to join the Budapest Convention is precisely the powers of investigation and enforcement that they were reading into the Budapest Convention or were questioning whether the Budapest Convention authorizes. And so we have a real debate about what is acceptable or not acceptable in this enforcement space, where countries are taking unilateral action also without clear elucidation, precisely of the kind that also needs legal articulation that Liis was alluding to.
Thank you. Yeah, I wanted to turn to you, Arthur.
Taylor, if I can pick up on the maybe domestic international distinction that you started with. I think one distinction to keep in mind, of course, is the distinction between criminalization and enforcement. And you can have international criminalization, for instance, after the Geneva Conventions, there's a large number or a quantitative of conduct that was clearly criminal during an armed conflict that was perhaps not as clearly criminal under the Hague regulations or beforehand. But there wasn't an international enforcement mechanism until decades later. Particular institutions are set up that have by other institutions or people that have the legal or states that have the legal authority to set them up and engage in enforcement under particular circumstances. So you can have an international crime, but still be dependent essentially on domestic enforcement of that crime through domestic courts, through either domestic or multilateral police action, something like that. And that affects, I think, states, prosecutors, and by states, I mean both in their law enforcement capacity and in their engagement in what we would term criminal cyber statecraft, their perceptions of the legal risk that Liis was talking about. If the legal risk for engaging in a particular act of cybercrime is, you can't visit a country that you were never going to visit anyway because you're under an arrest warrant there, then that legal risk may be negligible. And that country may perceive that the legal risk to publicly announcing a warrant is kind of similar to the legal risk of wagging a finger without accompanying it with the sanction, that it looks like a little bit of a paper tiger.
Great, thank you. I would love to invite the audience in for questions in just one moment. First, I'd like to do a very quick lightning round while folks are gathering their thoughts if they don't already have them. If you had to distill, we touched on a lot of different challenges, right? If you had to pick your favorite challenge, your biggest issue, what's most likely in this topic area to keep you up at night? I'll start with you, Liis, since I've been picking on Asaf.
Honestly, nothing is keeping me up at night. This is not for me a life and death matter. So, but I mean, when it comes to public, international, and cyberspace, I feel that there's been a lot of research done already on like the core issues, the key issues. So obviously, like when it comes to those unexplored issues, these are going to be issues on the margins. And with regard to this particular context, to me, the question of functional immunity is really interesting because I mean, there seems to be this growing body of state practice that appears to go against it. But when I say this, am I right or not? I mean, this would require proper research, and I think it would be fascinating to look into that matter.
So students looking for a PhD dissertation topic.
Maybe masters. Yeah.
Arthur.
I think I'm in the opposite position. Lots of things keep me up at night. We all have to be worried about more things. In this context, though, I think maybe the thing I'll add to the conversation is something like the need to define conduct that is subject to enforcement in a sufficiently narrow way to avoid adversaries, rogue states, rogue actors using that definition and that consensus to sweep in unanticipated conduct. And thinking about, for instance, the misinformation space, the working group on arbitrary detention, for instance, I've written about it being very protective of expression in the online context and critical of attempts to term things disinformation or misinformation. And in part, it's because those are terms that are often used by states to identify or to mean any information they don't like. And so being really precise in what conduct we mean as criminal statecraft, I think is really important.
Great, thank you.
Well, first, just because I feel like everyone said, I'm also sleeping fine. And but on the substance of it, I think that there is a real hard question about the relationship between permissible self-help and cyber vigilantism. And there is in a space that is, again, at least in a state of confusion about certain activity, in part because of the failure to sufficiently attribute or the failure to articulate what was wrongful, or the failure to set kind of legal boundaries around how do we prove what is internationally wrongful and continuously debate what is internationally wrongful. The result is also that states are continuing to act unilaterally in all sorts of ways. And even when they act collectively, they're still acting in ways that are pushing the envelope. And I think that there is the possibility there so far, that's the realm of IR scholarship on why haven't we achieved full cyber catastrophes. But there's the possibility of destabilization and miscalculations rooted in misunderstandings of what the conduct is. And I think that greater elucidation would serve everyone and is something that is growingly lacking in this space.
So 50% of us don't sleep, but that's good to know. Yes, Gary.
Thanks. Just a couple of thoughts and reactions. One, I agree, right? Enforcement has focused primarily on domestic mechanisms, but in the principle of complementarity says that international law prefers that. Interestingly, right? Even where we have enforcement mechanisms like the ICC or et cetera. But the functional immunity question, it is really interesting. I've not worked one of those. I have some suppositions, and I also have like my brother who has been a DOJ prosecutor and in the cyberspace as well. But it goes to the question of what you consider to be internationally wrongful within the context of what obligations are. I would analogize the functional immunity to any type of affirmative defense in a criminal action. And if I'm looking at a case as a prosecutor, that's a right that it draws on some of your points, that the attributed state can or can choose not to assert. So I don't know that in the decision making to go ahead and exercise that level of enforcement jurisdiction in the form of indicting and initiating a proceeding is an internationally wrongful act if you have a reasonable basis to believe that the other state may assert, right, on the defendant's behalf, the affirmative defense of an immunity. So it's an interesting question of whether just going ahead and actually indicting where that's a possible defense constitutes an internationally wrongful act in the first instance, or it is just that affirmative defense that can be asserted.
Just one quick reaction to that. In the wake of the Snowden revelations, there was a significant change in the way we do intelligence in this country. And one of those changes was the creation of privacy advocates who joined the FISC. And the entire process there was, we saw international pushback on the mass surveillance significantly underchecked by the court. And we needed, in an ex parte proceeding, to have someone speaking the other side's concerns in some respect. And we can debate whether or not this privacy advocate model is a working model, is a good model, is something we should emulate, and elsewhere. But the idea that the US cannot imagine in these ex parte proceedings, be them on botnet takedowns, and I have I've criticized botnet takedowns as being not sufficiently taking into account the potential harms that could be generated. We can talk about that offline if you're interested. But using the courts to, in ex parte proceedings to produce these particular actions can lead to problems, and not having the ability to take into account potential international concerns, potential harms to third parties, and so on. Those are things that is perhaps a problem that other countries might react to. They haven't yet. And so the functional immunity, Liis, tell me, because you're meeting these countries a lot more than I do, whether or not they are pushing back on these actions that these countries are taking.
I'm not aware of any, and I think if there was pushback, that probably would not be public.
Mm-hmm.
I think in part that's also, and it goes to some of the question of the value of naming and shaming, right, of attributing, et cetera, without some connected concrete consequence. Most of the time, there have been some instances where we actually have, I think, gotten custody over some of these international defendants, but most of our indictments are speaking indictments in the US for a reason. It's a message sending exercise. And some of that value isn't just to shame, it's to demonstrate, which could be done back channel, but it's also to demonstrate publicly, we have the capability and capacity to identify exactly what's going on here, right? So there's a lot that goes into the decisions about that, but the speaking indictments are often done with the knowledge that there's a low expectation of ever getting custody over the individual to see a day in court, right? And so you don't get the moments where the other state would step up, take responsibility, accept connection to this action and assert that defense in a court.
Any reactions?
This is not like fully my comfort zone because we're talking politics, and I completely yield to like people who take the like policy decisions. But an interesting question that we could think about is then considering that the intent of the indictments in your domestic context is communicative, like you said, and those indictments, they are not, as far as I know, usually accompanied by other actions. So there's just the indictment. There's a lot of factual information in the indictment. There are pictures of the accused, of the people suspected of or accused of the crimes. If that serves a purpose and without any additional quote unquote sanctions is an effective tool, a policy tool, why would the answer be different in the case of a public accusation that is pointing a finger that might or might not include a statement on the lawfulness of the activity that also includes facts regarding attribution? How do we know that it was the other state behind it? So why is the value of an indictment higher compared to a state accusing another state of an unlawful cyber operation if that accusation also includes that factual information?
And if I can respond to that, there's a few reasons. First, it's not limited to the sanctions of name and shame. It does make it a little bit more difficult for people to get on a plane and go on vacation. And that is a deterrent to some. It's not a very big deterrent, but it is somewhat of a deterrent. It also opens the door to being able to go after assets, because now you have a legal basis to seize assets where you can identify them and connect them to that offense. And it's also, in a sense, I think when we only have certain tools that we can use, despite the Snowden revelations and the concept that the United States just massively sucked up everybody's data. But anybody who worked in the government knows that's not true. There was a lot of talk about misinformation and disinformation. The story that came out after the Snowden revelations was fraught with misinformation. But we have certain legal tools that we can use to gather evidence. And if you're using criminal tools, criminal justice tools, then there's obligations of secrecy around what you collect. So using a speaking indictment is one way to tell the story legally, but we couldn't just take all that data and publicize it without filing an indictment. So there are legal reasons why it flows in the way it does as well.
We had a question over here, yes.
Thank you. Really interesting. I work at the Global Initiative Against Transnational Organized Crime. So this topic is extremely interesting for us, and actually we've been kind of looking into the issue of criminal statecraft. I have a different definition to throw at you later on. But one thing we've seen, kind of including cyber, but more generally, is our organized crime index, which looks at levels of criminality and resilience to organized crime all around the world, ranks state actors as the most pervasive, the most dominant form of criminal actor. So actually, the world we're dealing with now, as opposed to the turn of the millennium, we see as being characterized by blurred lines between who's criminal, who's state, who's business, and actually, it's not mafia-style groups or criminal syndicates that we see as the biggest enabler or kind of perpetrator, but state actors in various forms, whether at the high level or at the low level. And we've been working on a concept that we're calling geocriminality, actually. So this is the new one. So I'd be interested kind of in discussing more later, but what we see that is where states are instrumentalizing organized crime for foreign policy ends, usually where they're able to do what they like at home, where there's no democracy, rule of law, there's no constraints on what they can do domestically, but internationally, they're not able to kind of use traditional means to influence. So they're getting more and more enmeshed with organized crime, including in cyber. And I think kind of just to link to this to yesterday's conversation on the Cybercrime Convention, I'd be interested in the panel's thoughts is, we've spoken about legal responses in the panel, but what about multilateral kind of pressure responses? And for me, my experience working primarily on the UN TOC convention is that even when you have states that everybody knows are instrumentalizing organized crime, you're not allowed to talk about it. So for example, for us as a civil society organization, when we go to those meetings, we're not allowed to mention any countries by name. just have to talk about general trends. So, what suggestions do the panel have to kind of move alongside or outside of these structures to try and raise awareness in the multilateral space?
So you want to jump in on a very big and tricky topic?
I'll say that I want to talk to you afterwards, because a lot of what you said, I took avid notes of. At the outset, I think that the conversations we've been having on many of these things are not going to be resolved at the immediate level on a fully global stage. That will take the action of those who are already working together and better articulating what they're doing and how they're doing it. And so I think that there's a lot more benefit in the like-minded to come out with better articulations of what is criminal activity in these cases, how they going to move forward, apply the law neutrally and not through politically motivated means. I think all of these things are a necessity and could be the first step towards setting expectations better.
Maybe I should add that the reason why I raised the question of public accusations of other state cyber activities as unlawful had not so much to do with invoking the political responsibility of the states, but rather using them as a tool to make the point or to prove the point that international law actually is operational in this domain, that it's not just an exercise for lawyers, for foreign ministry legal advisors on paper, but rather that when there are cyber operations that do appear to go against the rule, that then in those situations, those rules are invoked and the state's activities are called out. I mean, this just, and not to mention the fact that it would help clarify the rules, because this whole multilateral conversation is centered on, okay, we have the rules, but how do they apply specifically? Well, one way to show how they apply specifically is in response to concrete incidents. So I think from the perspective of enforcing the rule of law in cyberspace, this really is the missing piece of the puzzle.
Absolutely. Yeah, Kuba.
And I mean, I would totally echo everything that Liis has just said. I think that would be really an important next step in the discussions that we have. But my question is about something else. I found it really interesting that you started with the scenarios and then you referred to them variously during your presentations. So let me add another one, and that's supply chain attacks. And I would really, because this is something that international lawyers have been scratching their heads around. And let me just briefly explain why. And then my question would be, following Asaf's very useful delineation between the law as it is and the law as it might be in flux. So I would be interested in your perspectives on that. So supply chain attacks, when they are done by states to further their objectives, as you have used in your different definitions, whether it has to do with IT products like software to later on produce some effect or do for espionage purposes, as we have seen with SolarWinds. But you can also think of supply chain attacks interfering with the hardware supply chain, as we have seen very prominently very recently with the so-called explosive pagers incident in Lebanon. And we don't know the exact facts of that, so I don't talk about that particular incident. But what I am wondering about is, we could say, oh, for the international law, it's just a matter of looking at what the effects are achieved down the line, and that's how we assess those incidents. So was it just espionage? Then those who take the view that espionage is tolerated by international, it's fine. It's an indiscriminate attack with lots of people dying because of the effects that are produced, then IHL might have something to say about it. But my question is a bit deeper. Because these supply chain attacks attack the integrity of the supply chain and the trust that we all have, in the devices in our pockets, the networks that we're working with, is this something that international law already says something before those effects are produced? And if not, should it? That's the question.
So first I want to say that the word trust before you said it. And Dennis Borders, for those who know him, has been long proponent of protecting the core of the internet as a position that also the Dutch government has taken on after the fact. And I need to contribute to a book that he's authoring called Spying on the Core. And a lot of the questions that I'm grappling with myself as we speak, and therefore I'm very triggered by your question, is that how do we allow for particular intelligence gathering activities without interfering with societal trust in critical infrastructure, particularly around the core aspects of the internet, from our trusting the DNS servers we use to trusting the pagers we carry around. And these are hard questions, but in my mind, the only answer to them will have to come from looking at the standards that exist in spaces that international law doesn't traditionally look to for identifying lex lata rules. And that is, say, the ethical standards to govern the way intelligence agencies operate. And so for me, and that's why I'm so passionate about this lex specialis of intelligence and I've written about it, the only way to start answering these questions is to start identifying where do intelligence agencies draw lines, where should they draw lines based on past practices that looks at intelligence as such, and not as intelligence in general by referring to general international rules that say so little by their design to concepts of trust and integrity. Because we are so focused with accessibility, unauthorized access. But there's, in the CIA triad, there's also integrity, not just access. And so that's something that we can talk about.
I'll maybe take a slightly different tack. I think I'll defer to Asaf on the intelligence collection side, but when you're talking about a supply chain in the context of something like a targeting question, I think, trust is a policy goal, but the targeting question is something that's more like, once you've decided something is an attack, either cyber or physical, once you've decided whether it meets the legal definition, and so consequently bracketing that question for the moment. The question is whether what's being targeted is something that has a specific military purpose or that otherwise meets the definition of a military objective, and whether what's being targeted is the whole supply chain or a shipment in the supply chain may be really important to making that evaluation.
Great, thank you. I see we're running low on time, but we've gotten some additional.
We started late, so we can, it's not a question. So we'll take a few more and shorten the break a little bit.
Great, Deborah.
Yes, Deborah Decker, Stimson Center. I was going to ask, the UNGGE in 2015 had their 11 norms, of which were expanded upon in the next UGE. And norm 13B goes into quite detail about asking for technical attribution. They went through the possibilities to have certain standards. Now, I don't know if the proposed program of action is going to take this forward, but future work could also consider how to foster common understandings. Now, UNIDIR, I know, has done a little ways towards that, but they haven't fostered that. And I know the Cyber Peace Institute has done some work on that. But can a civil society organization potentially take that forward? And Liis and I have talked about that to some extent, about looking at these laws and international law and these norms and just having a catalog of what the statements are about it and if action has been taken. And the diplomatic toolbox that EU has, is part of it. To say it's nothing. I'm kind of with Gary on the, if you have an indictment, if you have even a statement on it, I think it supports international law. So I just want to know, where is anything going forward with the group here on this? Because I think it's so important to foster it, either in the POA or among civil society actors or where.
I don't know, Liis, if you want to jump in.
So I just happen to have some training slides open in front of me, and I have the text of that norm in front of me.
Yeah, me too.
I don't know if they planned this. I was not.
But maybe make a comment about the norms more generally. I think, like, for an international lawyer, the norms are a little bit unsettling because there's so much focus on norms, and you can make an argument that the focus on the norms and invoking the norms in the face of foreign state cyber operations, it's actually taking away from the law, is to an extent devaluing the law. Because if we think of law as the foundation of a rules-based international order, and then on top of that we have the norms, and the way the norms were designed was to sort of operate independently of the law, then it's great that the norms are invoked. It's great because also they are cyber-specific, whereas the law is not cyber-specific, which makes them easier to be invoked. If we're only seeing invocation of norms and not the law, to me,
that it would be both. That it would be, you would first state international law, because that is, to your point, is agreed, and then also the norm if you need it. but just to
There-
strengthen both international law itself.
There is an argument to be made in support of that sort of objective as well, because if you take a very legalistic reading to the norms, then many of the norms actually, you can see that they received input from lawyers. So the norm against attacks against critical infrastructure, it refers to cyber operations that go against the state's legal obligations that are directed against critical infrastructure and hinder the provision of services to the public. So, I mean, you could make an argument that when this particular norm is invoked, like Albania did in 2022, that Albania implicitly was also then recognizing that the Iranian operations against Albania ran counter to international law. I mean, that's very like legalistic and technical look at the matter.
Can I just connect that question to the previous question about trust? Because I think that partially some of your answer is also in that space. Francis Fukuyama says that, I'm quoting him, trust does not reside in integrated circuits or fiber optic cables. Trust resides in social constructs that exist within a community. So when you are talking about civil society organizations doing the attribution, partially it's our decision to trust their statements more than the statements of states, and or to create communities that we trust as the diffusers of information vis-a-vis what is a protected network or not protected network. Because part of what trusting is a vulnerability. I am putting myself at risk by trusting another person. And often, since I will not have the capacities or desire to do the research on my own, I will turn to others who I trust to convey to me the information I need on how to act in a particular circumstance. And so what the opportunity I'm seeing is that there might be, and in all these domains, there have been groupings that have played the role that the techie community trusts what they say, or that from Citizen Lab in the context of attributions to whatever ICANN in the context of particular internet protocols. There might be communities of trust that we can turn to, and then protecting what they say and elevating what they say might be a necessity.
Great. So I see there's quite a few hands. I'm hoping to just maybe grab a couple of questions, and then I want the panel to respond to what they hear and also provide some last minute summations. Yes, over here.
Thank you. Typically, when we have these discussions, the way in which they proceed is we start going to these rules that we have been chewing on for so many years, like sovereignty, non-intervention. Then you have some people like Asaf, who really scan the entirety of international law to find the best analogies and the best comparators. But I was wondering if there is something else that can be said about the linkage between criminalization conventions for individuals and state responsibility. And what I have in mind is whether it would be possible to infer negative obligations of states to not engage in cyber crimes from criminalization conventions. Now, the International Court of Justice did that with the Genocide Convention, which doesn't speak about state responsibility, but it did infer an obligation of states from a criminalization convention. Can something similar be done for cybercrime conventions? And if so, why so? And if not, why not? And the reason why I'm asking this is that this can open quite a few procedural mechanisms. If you think of the Genocide Convention, what it has given is the recourse to the International Court of Justice. And it might also be the case that procedural platforms will open by looking this way at cybercrime conventions. Thank you.
Great, thank you. Any other questions? Yes.
So sorry, going back to the issue of immunity, I'm wondering if the developments we're seeing might not be as dramatic as they might seem, because I think traditionally espionage was considered something which wasn't really subject to functional immunity. I think this is the point that Romano Kolodkin, the former ILC Special Rapporteur on immunity for official acts, made in one of his reports, and I think also picked up on by some of the scholars in the field. So maybe what we're essentially seeing is the kind of natural progression of this non-application of immunity just in relating to cyber espionage.
Great, thank you. So two questions, one about linkages between criminal conventions and state responsibility, another about immunity and natural progressions when it comes to espionage and other factors. But I also want to, in our last couple of minutes, perhaps we'll start with you, Arthur, if that's okay. Mix up the order, and then we'll go to Asaf and then Liis.
Sure. I think perhaps on the first question, I point to specific aspects of the Genocide Convention that allowed for that type of evolution, right? There is a dispute resolution clause in the convention whereby states parties that don't include a reservation on that specific article agree to have disputes about the interpretation of the convention submitted to ICJ. So you'd have to have not just criminalization, but a specific internationalization of the dispute resolution process in the criminalization convention for cybercrime to have the same type of effect. Beyond that, I'm not sure I have any huge macro thoughts on the subject of the panel, but I'm grateful to have been here and heard from both of you.
Thank you so much, Asaf.
So in that article, the Law and Politics of Ransomware, I get into a deep dive into my analysis of whether the Hostages Convention could be applied to ransomware or particular ransomware acts. And it's a deep dive that led me to many conversations and debates with people and how we interpret particular words. And maybe kind of a step out from that, there's two options available to any kind of regulators who is interested in regulating law and technology issues. One is to take existing treaties or conventions you have and trying to expand their edges to fit a round hole in a peg, or create new treaties or new frameworks to. And my approach, in line exactly with the intuition that you have, is that we should do both in as much as we can in a space where we're suffering from under enforcement. But predominantly, and as I say there, without us needing to create a universal jurisdiction for ransomware as such, we might rely on the universal jurisdiction for hostage taking and apply it for a particular category of ransomware. Just gives new avenues for parties to act in a space where they're struggling to come up with creative multilateral. So completely take that.
Great,
Maybe
thank you.
just a very short comment on the immunity question. Even if that was the case, if functioning immunity was not, a problem for espionage charges, then that still leaves the problem of all other charges. Conspiracy to commit wire fraud, whatever charges they may be, where if it's not an espionage charge per se, then would your solution work in those cases as well, where the charge is not directly an espionage charge? I don't know the answer to that question.
Great. Well, I think we should wrap here. Thank you very much for giving us an additional 10 minutes of your break. And thank you to the panelists, Gary, Kathleen, Laura, and everyone for organizing this excellent conference.